This Week in Law is up next with me. I'm Denise Howell, Emery Roan, my co-host, and our guest, John Turanian. We found some surprising things on the blockchain, including Disney and weed, Sweden bans camera drones, Hulk settles with Gawker, nasty IP, and much more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, Emery Roan, and Mike Keys. Episode 366, recorded November 4th, 2016. Miss Jackson, if you're litigious. This episode of This Week in Law is brought to you by FreshBooks, the super simple cloud accounting software that's giving thousands of freelancers and small businesses the tools to save time billing and get paid faster. Try it free at freshbooks.com/TWiL. And by Grasshopper. Stay connected and run your business from your mobile phone with Grasshopper. To save $50 on your order, visit trygrasshopper.com/twit. Hi, folks. It's Denise Howell, and you're joining us for This Week in Law. We're so glad that you're here. We have a wonderful return guest joining us this week, attorney and professor John Turanian. Great to see you again, John.
Oh, very nice to be here, and thanks for having me on.
John's a trial lawyer. He has his own firm right here in my neck of the woods, Orange County, California, called One LLP. He focuses on IP and entertainment litigation. He's a professor both at Southwestern Law School and at the Biederman Entertainment and Media Law Center. I miss anything there, John?
Nope, that's good.
All right. Also joining us is my co-host, Emery Roan, who is a third-year student at California Western School of Law in San Diego, and an intern right here at TWiL. Great to see you again, Emery.
And great to see you as well, Denise. Thanks for having me. I was saying, before the show, I leave for 1 week, and then all the copyright news in the world crashes down. So I think we've got a lot of great topics to talk about this week.
We do. The DMCA is very much on our agenda for the week. I was just noticing, John, that you had opened an office, right? Your firm has its second office now in San Diego near Emory.
Oh, really?
Third office, actually. We have an office in Beverly Hills that we've had for a number of years, and we just did open up an office in Del Mar in that tech corridor in Del Mar Heights area. So, yeah.
Oh, wonderful.
Great. Yeah.
Good to see you guys growing. All right, then let's plunge into that DMCA stuff. Let's start with a change from the Copyright Office that, if you're not a lawyer, might have completely escaped your attention, but it's quite an important thing to be aware of. And it's the first time in reading over an analysis of a development from the Copyright Office or anywhere else that I've seen Professor Eric Goldman use the term FFS in one of his posts. Really got him riled up, and I can understand why. What happened here is the Copyright Office has sort of been hinting and has been soliciting and receiving comments about the notion that it's going to change its registration process for the people who receive notices under the DMCA on behalf of companies. These are called their designated agents. And you have to have one of these persons designated in order to benefit from the DMCA safe harbors. And for a long time, the Copyright Office has wanted to switch to an electronic record-keeping system and an electronic submission system for these designations. And it's decided to do this. But it also decided, it would be too hard to scan and too expensive to scan all the paper registrations we've had over the years. And oh, by the way, those are probably getting out of date anyway. So we're just going to take the opportunity to make everyone re-register. And we're going to start making them do that every 3 years. The way it's been up till now is you could register once and that's it. That's all you'd have to do. And you would always be able to enjoy, you would have a place for people to be able to send notices. And once again, whatever you registered as your agent with the Copyright Office wouldn't necessarily be the place where notices needed to be sent. You just needed to let the Copyright Office know that you ticked that box, you had a registered agent, and hence were desirous of using the safe harbors under the DMCA. Well, what this winds up meaning, it's not going to take effect until the end of next year, but if you haven't re-registered using the new process by the end of next year, you're going to lose your safe harbor protection. And that's a big deal, isn't it, John?
Yeah, it absolutely is. I mean, for the DMCA, the consequences of not having a registered agent are pretty draconian. It's black and white. The case law says if you have a registered agent, you may qualify for the safe harbor. If you don't have a registered agent with the DMCA, you per se cannot qualify for the safe harbor. So this makes an immense difference. And I think Professor Goldman is right to be very, very skeptical of this proposed measure. I kind of think about the USPTO's transition to a online system a number of years ago, and thinking about what the consequences would have been if the Patent and Trademark Office had told all the people with registered patents and trademarks that their registrations are invalid and they have to re-register simply because the USPTO doesn't have the time or energy to rescan old paperwork. That certainly didn't happen. People would have been up in arms, and I think rightfully it is problematic. The Copyright Office probably should be spending more time worrying about the issue of online registrations and creating a database of registrations that are much more searchable. Its database is woefully inadequate for a 21st century digital environment.
And Dallas in IRC is reminding me we should back this up one step further. He's asking what a safe harbor even is, why it's important to have one if you're a company. Emery, you want to take that?
Actually, I want to punt that over to John as I answer some questions in the chat. John, do you mind giving us a quick intro?
Yeah, not at all.
Of safe harbor?
Yeah.
Sure. So the DMCA is, of course, the Digital Millennium Copyright Act passed in 1998. It provided a limited safe harbor for internet service providers of 4 types. Most commonly, this is also known as the YouTube safe harbor. This is what enables YouTube to operate without facing copyright infringement liability for all the acts of potential infringement that may occur on its network based on the direction of the users. And so the DMCA safe harbor was intended as a way of protecting internet companies from copyright infringement liability when they were operating in completely passive ways without making decisions regarding content or curation of content. And it's tremendously important because it's given breathing room for entities like Pinterest, YouTube, Facebook, Twitter, et cetera, to come into the economic forefront without facing billions of dollars in liability. At the same time, it's raised a lot of issues for content holders who see massive infringement on networks such as YouTube and are frustrated with their inability to be able to do much about it. But the safe harbor is incredibly important to internet companies, and preserving the safe harbor requires a number of steps that are dictated by Section 512 of the Copyright Act. One of those steps is having a registered agent with the Copyright Office, and that's what we're talking about.
Right. So as long as you've jumped through the hoops that the Copyright Office puts in place to be able to benefit from the safe harbors, you can benefit from them. And it's, as John points out, it's super important to just about every business that has the ability for users to use their site as a platform in one way or another, whether you're a photo sharing site, a video sharing site, a link sharing site. If your users are aggregating information and posting it to your platform, some of it's probably going to be identified as infringing in some way. And so as the operator of the site, you want to be able to take advantage of the fact that you have some protection, you have a process to go through. And that process is you receive a notice from the copyright holder, and you respond to that notice, usually by taking it down. And then the person who posted it originally has the opportunity to respond to that process. So there can be a back and forth of the item in question being visible on the site, not visible on the site, perhaps restored to the site, and the parties go on their way. If the parties wind up at a stalemate, then the rights holder might have to sue the person who posted the material. But the site operator at that juncture, if they've done everything they're supposed to do under the safe harbor, they should be insulated from liability. Did I get all that summarized to your satisfaction, John?
Absolutely. Yep. No, that's perfect. And the registration requirement of the designation of your agent with the Copyright Office is the first part in those series of steps that you alluded to. You need to respond in a timely manner to take down notifications. You need to have a policy that's and reasonably implement that policy regarding repeat infringers. You need to not exercise control and financially benefit from the infringement. And if you meet all of these basic requirements, then you are eligible for the DMCA and the safe harbor.
Right.
And what changes here, I guess, is that the DMCA registration process was up until now basically like a do it once and forget it, a one and done ordeal where, like, for example, New Media Rights, the other nonprofit that I intern at, we work a lot with, entrepreneurs and startups that are, bootstrapping their work. And a lot of what we do is sort of giving them the documents that they need to get their web platform off the ground or get their community up or get their app running. And what we do is we frequently, write a memo explaining how they register their DMCA agent, write in that memo, explain as much as we can their proper implementation and the procedures they have to follow. But we then, hand that off to them, and then that's up to them to handle it from then on with, that expectation, with our expectation that they've read the memo and can basically handle all the steps moving forward. This process, this new rule change really means that all of those businesses that are, one or two people, one person operations even that, may have thought that they've had all their legal compliance handled 3 years ago, may suddenly find that they are not compliant with the DMCA. And as John and Denise were saying, that's some pretty huge implications if any infringing content is found on their site.
Yeah, one other thing to add. Yeah, if I may, Denise, one other thing to add. I don't want to completely dismiss the Copyright Office's move here. This isn't a case where they're creating a solution in search of a problem. There is a problem. It's just not being fully identified or maybe not being addressed in the proper way with this proposal. And that is, there should be an ability to digitally search the DMCA designations. And as of now, you can't digitally search them. You have to literally call up the scanned PDFs, and then you have to manually look at what websites are listed. And for litigants who are trying to ascertain whether a particular website is properly registered under this requirement, it's very hard because you can't do a search on the Copyright Office website naming the website. And so I do applaud the Copyright Office for at least understanding that there is a problem, much like there's a problem with trying to figure out if a work is registered. It's very onerous to figure that out on the current Copyright Office website. However, this particular solution, I think, is certainly problematic for the reasons we've identified.
Yeah, I mean, in a lot of ways, it's like, one step forward, two steps back. Like, for example, I always thought it was weird. I think that most people probably think it's weird that, if you are a website owner or a business, in order to register your website for protection under the DMCA, you have to physically send in or fax a piece of paper that's then not able to be searched electronically. It's kind of crazy that, for your website, there's no electronic submission process. So on that regard, I think that everyone can basically agree that, way back in 2011 or whenever the Copyright Office first, brought this subject up, people were saying, yes, we need an electronic registering system. That's great. And, again, as far as benefits that this rule change brings, it is, dramatic cost savings. You register every 3 years, but it's gone down from previously registering your DMCA agent cost $105, I think, and then an additional $30 for each additional domain name you want to register. That's gone down to $6. So, I mean, I'm not very good at math, and I'm trying to do this off the top of my head, but it would take many years for your $6 of every 3 year registrations to add up to what your single registration cost beforehand. So certainly it's great there. But yeah, absolutely. It's clearly problematic in other ways.
Right. And what I wanted to address, too, is a comment from IRC from Omega Project there. I think his comment based on when he posted it was in response to the description that I gave you guys a moment ago about how there can be this back and forth, and frequently is this back and forth, especially for sites like YouTube, of the item in question being on the site and then off the site, and then people have to respond, and maybe it goes back on. The comment was, it sounds like a full entertainment lawyer employment act. And I could see where you might think that, but and certainly companies like YouTube do have extensive staffs that do nothing but review takedown notices and put back notices under the DMCA. But the whole point of having this safe harbor is that having those staff people in place and doing this review is still vastly more efficient than having potential for each and every one of those activities to result in a lawsuit.
Well, that being said, I think that John, I mean, the other link that we have in our show links this week is an excellent paper I think that John published about the censorship effects of the DMCA and copyright. The new censorship. In your paper, obviously you can expound on this better than I can, but you talked about how yes. The DMCA is supposed to be a way of getting around these expensive, settling this out in court, but it's not exactly working out that way. Do you want to expand on that a little bit better than I can?
Yeah, I mean, my paper deals with copyright law more broadly, both in terms of copyright infringement litigation as well as the operation of the DMCA. But the basic argument is increasingly over the last decade, we've seen a troubling rise of copyright infringement claims that aren't really grounded in rights holders trying to vindicate any real economic interest that they hold in their copyright. Instead, these are disingenuous copyright claims that are brought to bear against social and political opponents that the plaintiffs sort of want to take down or create, have a vengeful lawsuit against. And they basically drum up a copyright claim. And the reason this happens is because really of three factors. Copyright infringements are ubiquitous. It's incredibly easy to capture someone engaging in a copyright infringement if you look closely enough. If you monitor someone's daily life, we all technically infringe copyright law multiple times a day. Secondly, they're relatively easy to prove, especially with digital fingerprints and all of that. And at the same time, there is massive liability for copyright infringement, especially when you're dealing with timely registered works, where currently the law provides up to $150,000 in statutory damages per actual act of willful infringement without any kind of real First Amendment defenses. And so what we've seen in recent years is lawsuits between people on all sides of the aisle, whether it's pro-choice activists suing pro-life people for using their footage, or pro-life activists suing pro-life people for using their brochure materials or videos. We've seen a multitude of lawsuits where individuals really drum up false copyright claims in a way of seeking revenge against people they simply disagree with socially, or to keep information squelched. There's a great, and I say great, not because it's a good result, but rather a perfect illustration of this problem from a recent suit from the Ninth Circuit a couple of years ago involving two Latino celebrities who had always maintained that they were single, and a tabloid, a Spanish tabloid, had gotten hold of their wedding photos, published their wedding photos to basically refute the allegations that they were single. Now, this may not be the Pentagon Papers, but this was an important enough issue to people, and certainly something that would ordinarily be protected under the First Amendment. The celebrities couldn't do anything about this under the First Amendment, except if they drummed up a copyright suit. And so what they did is very cleverly purchased the wedding photos from the Vegas photographer who took the photos. Got an assignment, and then pursued a copyright infringement claim. And of course, there really isn't a whole lot of First Amendment defenses in copyright law. And they ended up prevailing against the tabloid, even though the tabloid was making use of these photos to specifically refute allegations on the public record that the celebrities had made saying that they weren't married. Again, a clear case of censorial use of copyright simply to prevent unwanted information from being discussed in the public record. And to me, a clear case of the abuse of copyright litigation. And we see suits like this all the time. I mean, there are some absurd suits involving people in divorce proceedings suing their former spouse for revealing manuscripts that were embarrassing to them as part of the child custody proceedings. How did they get around normal rules of divorce court, which would consider that kind of stuff admissible? They claimed a copyright infringement for the reproduction of the manuscript. So, so it's a disturbing trend we've seen. And in the DMCA context, we see this because there is not a whole lot of incentive at the current time for rights holders to take a narrow view of copyright when they send out DMCA notices. In fact, they take generally a very broad view of copyright, and we see this in the current pending litigation, the Universal v. Lenz case, which I know is one of the other items we were discussing. In that case, of course, it's the famous case involving the dancing baby from, I think, almost 9 years ago, where a mom put up a video of her young toddler dancing to Prince's "Let's Go Crazy." And Prince's record label served a DMCA notice, got the video taken down. And in the view of the mom and the people who ended up representing her, quite wrongfully, because it seems like it was a quintessential type of fair use, where it was simply background music that was being played. But one of the key issues in that case, and that's so far been decided in a way that is highly unfavorable to copyright users, is the court held that you merely need to have a subjective belief that there is infringement going on. There doesn't need to necessarily be an objective good faith basis for your DMCA takedown. And a subjective good faith belief means that if you take the position and truly believe that your copyright is your property 100% and no one should have the right to use it and they should always ask you for permission, and you truly believe that's the law, you can go out and send out takedown notices and prevent use of your copyrighted works without any kind of legal consequences against you. And that seems highly problematic, especially from a censorship point of view.
Right, and
I think it's so interesting that so many of the censorship argument or the censorship problems that you were talking about. And really, I guess most of the misuse of the DMCA and misuse of copyright law generally, I think, would be mitigated by strengthening the fair use doctrine. Would you agree with that, or at least providing some more predictable outcomes to the fair use analysis?
I think predictable outcomes is certainly helpful. I think there are a number of problems, though, with fair use. First, there's a weight of precedent now where, you can argue any outcome you want from fair use because all the situations are so unique, and there's case law that's all over the map. I mean, even, there's case law showing even the most de minimis infringements can give rise to liability. Of course, there are cases that say that's not the case. And I think fair use is a bit of a mess. And my other problem with fair use is it takes a long time to figure out if something is fair use or not. You typically don't get fair use holdings at the motion to dismiss stage, which means if you're involved in a lawsuit, to vindicate your fair use rights, you have to go very deep into that lawsuit, into the summary judgment stage. And most defendants simply don't have the economic resources to pay a couple $100,000 to a law firm to get to that point, to find that, in fact, they have engaged in fair use. And so more often than not, they may kowtow to the rights holder because simply they don't have the resources to fight. And so one of the proposals I make in the piece is actually suggesting that we need a more express First Amendment check on the copyright law outside of the scope of fair use, which is an affirmative defense that can only be raised as an affirmative defense, with a burden of proof on the defendant. And one of the things I argue is that just like tort law has developed a series of First Amendment defenses, and the most famous of which is New York Times v. Sullivan, right, for defamation law. The Supreme Court very famously several decades ago said that in certain cases when you're dealing with public figures or issues of public import, to prevail on a defamation claim, you have to make additional findings. Namely, you need to show actual malice. Just as the courts have done this additional requirement in cases of tort, actions where there is a significant public interest issue involved. I think for copyright law, where litigants are not truly vindicating an economic interest, and where the effect of a lawsuit would be to suppress information on an issue of public interest, I think it would be very reasonable for courts to sort of have a heightened requirement, an early showing by the plaintiffs in order to proceed with the lawsuit, kind of a New York Times v. Sullivan for copyright law.
Another thing you brought up in the paper was strengthening the 512F punishments, I guess, penalties.
Yes.
Do you want to talk a little bit about that as well?
Sure. So 512F, for those who don't know, is the provision in the DMCA that I was alluding to earlier, which creates a cause of action that punishes rights holders, that purportedly punishes rights holders that are overly aggressive in their takedown notifications to websites. For example, a classic case might be the case of Universal v. Lentz. And in fact, Ms. Lentz, when she sued Universal, her cause of action was 512. Claiming that basically Universal sent a takedown notice that exceeded the scope of its rights. However, courts in interpreting 512, as I mentioned, have generally taken the notion that plaintiffs merely need to have a subjective good faith belief that the activity is infringing, not an objective one. That's problematic. And have also taken a very narrow view of the damages available. One of the things that I throw out as an idea is in copyright law, we have statutory damages for plaintiffs because it's hard to capture the true damage that occurs when someone infringes your work. It's hard to prove because of the intangible nature of the copyright monopoly. And I think statutory damage is certainly appropriate in certain contexts. They provide punishment and provide an ex ante reason for people to license instead of infringe. But by the same token, I would suggest that if rights holders are overly aggressive about their rights and take absurd positions that fair use doesn't exist at all, there should similarly be statutory damages available for users of copyright works who are subjected to unlawful takedown notices.
Yes, absolutely.
So, John, we've had a couple of examples on the show in recent episodes that I think sort of loosely fit into what we're talking about here, whether it's a misuse of copyright law as censorship, what's going on there or not, whether it's a perfectly valid use of exercising one's copyrights. The first one that comes to mind, and I know it just really rubbed Emery the wrong way when this came out, was someone made a mod for Grand Theft Auto where that was capitalizing on the fact that the Galaxy Note 7 catching fire was much in the news. There we go. If you're watching the video, you can see how the mod works. You were able to use your Galaxy Note 7 in the game as a weapon that could fire fiery blasts. I guess it was Samsung who decided there was some sort of copyright that they could cobble together here in the image of their phone being used in a game mod this way. And they started sending takedown notices to YouTube attempting to extinguish all of the instances of videos of this mod. Clearly, they didn't succeed. We were just able to play one. But I'm wondering what you think. First of all, I mean, it's hard to figure out, and we talked about this on the show when we brought it up. It's hard to figure out what copyright they are identifying here in an image of the phone. But assuming that they have one, do you think that this is sort of a censorship exercise, that they think it's bad PR for them for the Note 7 to be depicted as a means of mass destruction?
Sure. I'd say this is a closer call than some of the earlier examples I gave, which were clear-cut cases of censorship. Here, Samsung may have some economic motivation Certainly in terms of keeping their brand, clean and squeaky, although that's problematic certainly at this point for them, and also in potentially raising licensing revenues for the use of the image of their brand. But that said, there is certainly a lot to be concerned about their strategy because. If, for example, we can see evidence that they haven't had any issue with Samsung phones in Grand Theft Auto mods before, except when they're exploding, that certainly seems to be evidence of a sensorial motive where all uses of Samsung phones are fine unless they are negative and specifically pointing attention to a very serious public safety issue that has emerged with their phones exploding sua sponte. Right. So that might be a case. And again, like you, I'm also baffled as to what the basis for their copyright claim is. It may be a very, very thin copyright in the design of the Samsung phone, but certainly it's a useful article, and their functionality aspects of the design would certainly prevent too much of a copyright protection on that design.
Right. And there was one other thing we covered recently that I thought would be interesting to bring up again in this context. And that was a gentleman named David Quitos, who took the photograph of the bowl of Skittles that Donald Trump Jr. famously and controversially tweeted. David Quitos had posted that photograph to Flickr without using any of the Creative Commons licensing strategies that Flickr makes available to people who can post there. You can either retain all your copyrights, which is what David did, or you can grant some licensing and allow various uses of your photos. David did not do that. So when his photo was pulled out and used in this way, he used the Digital Millennium Copyright Act to take it down from Twitter. And then he actually went so far as to bring a suit, which is now pending, saying that he was never asked for permission to use this photo and it's an infringement, and he's pursuing that. And I'm wondering, since there is a speech aspect to what's going on here, I'm wondering how it fits within your censorship analysis.
That's a good question. With respect to this particular example, I wouldn't, the suit may be misguided. The suit may be vengeful. The suit may be seeking monetary damages far in excess of what the actual licensing fee for a stock photo of a bowl of Skittles might be. All of those are well taken, but I wouldn't categorize it as a censorious lawsuit. And the reason is, the use of the particular image was not in any way to conduct any kind of serving a public function or to put out information about Skittles or about that particular photo. Unlike, for example, say a manuscript where someone confesses to killing their father, where it might be relevant in a divorce proceeding, or a photo of the Latino celebrities getting married even though they claim they're single. There, the actual use of the work and the lawsuit preventing the use of the work is trying to suppress information contained in the work. And so I wouldn't say the Skittles lawsuit is censorious in any attempt. The photographer there is simply trying to obtain a licensing fee for the work that they've created. Going that far with the litigation may be profoundly misguided, but I wouldn't say it's censorious.
Right. Even if one of the motivations on the photographer's part is that he just is not a Trump fan, maybe is a Clinton or Sanders supporter, or maybe just didn't approve of the message that Donald Trump Jr. was trying to send by using this photo, which was in reference, it was a visual demonstration in his mind of the U.S. immigration problem. Even if he has a philosophical objection to the way the photo is used, you don't think it's censorship if he's using copyright to take it down?
No, because, again, this guy's in the business of licensing photos. He does license the photos for money, and he's simply trying to vindicate his rights. Again, as I said, it might be misguided, but this is very different than, say, the Samsung use where the actual image is relevant to a matter of public issue. And there's no other way to convey that information except to show the Samsung phone blowing up or right.
Right.
So, there's plenty of ways to tackle America's immigration problem without using a Skittles bowl. Certainly Donald Trump Jr. could have used someone else's photo of a Skittles bowl, or he could have used his own photo of a Skittles bowl. He didn't need to use the photo that this individual had taken. So, although, certainly there may be a sensorial motive, I don't think there's sufficiently enough interest, in terms of speech on a matter of public concern here that would make the case sensorial.
I think it's interesting. I'm not sure if I follow why economic censorship is necessarily or should be exempt from the it seems to me that rather political and philosophical censorship and economic censorship are probably really closely related, in that you frequently have them both overlapping. It seems like any kind of censorship like that would still fall under 512F of being a knowingly, like a fraudulent takedown request or a fraudulent copyright infringement notice. I guess, do you care to expand on that? Why you chose to draw the distinction between economic censorship and just political and philosophical censorship in your paper?
Sure. Yeah. In part, it's because of the governing principles of copyright law. I mean, if you look back to copyright and, in the Constitution, certainly the Copyright Clause and the origins of the 1790 Copyright Act, copyright is largely an economic incentive. It's to reward individuals for creating. And to give them a limited monopoly. That monopoly should be limited. But at the same time, the economic reward on creativity is a fundamental part of the value of a copyright. It's not necessarily, and that's why I draw this distinction. I mean, if you went down the road of effectively saying economically, deciding not to give licenses to people is a form of censorship, then you'd subject all of copyright law and all of copyright enforcement to this heightened check. And you could arguably say that all copyright laws is censorship. After all, let's say you don't license your work to poor people because they can't afford your license. Is that censoring the poor from using your work? Well, in one sense it might be, but I don't think from the point of view of what I'm talking about it is. And that's why I would draw the distinction. I think taking your copyright monopoly, which is really fundamentally an economic monopoly, and leveraging it into a political situation where you are actually suppressing speech about an issue of public concern, is where I think this real problem of of copyright censorship is most pressing. That said, I agree the definition is incredibly difficult to determine. And I think that's one of the challenges that's going to face courts as they address these issues and try to suss out exactly what the motivations of litigants are.
Yeah, I could just foresee that in any kind of litigation, it would be fairly easy, I guess, to frame it as an economic decision rather than a political decision. When you could say, like, oh, I'm not actually sending this request to, get rid of their business. Or I'd have to think this through, but it seems like it would be a really tough.
Let me give you examples. Yeah, let me give you a few more examples, or also take the examples I gave. I mean, in the case of the wedding photos, those photos were not economically being used at all. There was no licensing market for them. In fact, they didn't even own, the celebrities who were the litigants didn't even own the photos until they acquired them specifically to sue. In the case of the manuscript submitted in the divorce case, it was an unpublished manuscript where the individual had no desire to ever exploit his rights. So there was, again, no link to economic use. Another case that's an interesting one is a case involving 4 Navy SEALs who sued the Associated Press for showing some photos of them engaged in activities that appeared to be torture with prisoners in Iraq during the Iraq War. And again, these people weren't going to be licensing that photo. There's no, it doesn't pass the laugh test to suggest the SEALs were out there with a vigorous licensing market trying to sell photos of their acts of potential torture. Rather, their use of copyright law in that case was specifically to punish the AP for bringing the photos that were the chief evidence of this alleged torture to light to the American public. And so I think these are cleaner cases where really there is no economic marketplace. There's no intention by the plaintiff to ever exploit that economic marketplace. And so it's very clear that the motive there is purely one of suppressing the very fact of the speech from being out there in the public record.
I guess I'm just more concerned, or I'm not more concerned, but I am concerned about, business to business DMCA, strategically wielding the DMCA to, take down content. But yeah, I think that anything that we can do to improve this process is welcomed. So, yeah.
Right. John mentioned the Lens case a moment ago. We have some news on that this week from the Supreme Court that we're going to get to in a moment. But first, we're going to take care of some housekeeping. We'll put our first MCLE passphrase into the show. We put these phrases in case you like to watch or listen to the show to get CLE, that's continuing legal education credit, in your jurisdiction. A lot of lawyers in the United States do that in various ways, and we're one of the ways you can do that. If you'd like to get more information about that, go to our wiki at wiki.twit.tv, find This Week in Law there, and there's a whole chart of how you would go about submitting for credit in your jurisdiction, if that's something you like to do. And I think there are various people who even listen who are not lawyers, who get professional education in their field for listening to the show. So we put these phrases in case you have to validate that you've actually watched or listened to the show in your particular jurisdiction. Our first phrase for this episode will be bada boom. In honor of the Note 7 mod. I wanted to mention, too, we've been mentioning a lot of John's article and the various stories that we've reviewed in advance of the show. If you want to take a look at those at all, if you want to dig deeper, and there's certainly much more meat both to John's article and to Professor Goldman explaining what's gone on with the Copyright Office, et cetera, head on over to tagpacker.com/user/thisweekinlaw. All of our links for each episode are aggregated there. And you can also follow our Flipboard magazine. If you find me on Flipboard, I'm Dee Howell there. This Week in Law is one of the magazines I maintain, and lots of other people are maintaining it with me these days, Emery included. John, you're more than welcome to jump in. I'll send you an invite after the show if you'd like to contribute on Flipboard as well. There's a link on my.
Thank you.
There's a link for anyone in the audience who wants to contribute to our Flipboard magazine. If you go to my Twitter page, it's pinned to the top. So just click that link and you should be able to sign up. Yeah. Also, we'll thank our first sponsor for this episode of This Week in Law, and that's FreshBooks. FreshBooks has launched an all-new version of their cloud accounting software that you really need to check out. It's been redesigned from the ground up and custom built for freelancers and small business owners. FreshBooks has created a super intuitive tool that makes it easy to create and send professional-looking invoices in less than 30 seconds. You can easily customize your invoice with your logo, your color scheme, any image that reflects your brand. Watch the copyright in those images when you're using them. Chat with your client regarding an invoice once they receive it. You'll be able to see what invoices have been sent, viewed, and paid, as well as overdue and outstanding invoice totals. The modern and simplified dashboard works as the hub of your business, answering the most important question: how is my business doing? You'll have quick access to outstanding balances, spending, total profit, and accounting reports like sales tax summary and profit and loss. Tracking expenses is as easy as taking a photo of your receipt using the FreshBooks app. You can track expenses by vendor and by category. Time tracking makes it easy to bill time by client and for specific projects. You can easily start your timer and track your time to the minute. When it comes time to create an invoice, you'll know what you did and when you did it. Get ready for the simplest way to be more productive and more organized. Most importantly, get paid quickly. FreshBooks is offering a 30-day unrestricted free trial to our audience here at This Week in Law. To claim it, just go to freshbooks.com/TWiL and enter This Week in Law in the How Did You Hear About Us section. Start your 30-day free trial today. Thank you so much, FreshBooks, for your support of This Week in Law. All right, let's talk a bit about what's happening with the Lens case. This case has been wending its way through the courts for quite some time. It resulted in a Ninth Circuit decision last year, right? I think it's that old now, that John was talking about, that imposes this. On the one hand, it's good for the fair use doctrine and for people hoping to use that doctrine, because it does find that before you send one of these takedown notices we've been talking about, you have to at least consider fair use and decide whether, gee, is this possibly a fair use of the work? And maybe I shouldn't send the takedown notice because of that. But the Ninth Circuit also said, in making that decision, you can have a subjective understanding of whether it's fair use or not. You don't have to go out and do research. You don't have to hire lawyers. You can just say, looks like fair use to me or not fair use to me. So I'm going to make the decision based on that. That seems to be what the Supreme Court is considering right now, pondering right now, in deciding whether it's going to review this decision from the Ninth Circuit. They've asked the Solicitor General to weigh in and give them some more information. Specifically, what they've asked is whether the Solicitor General thinks that subjective fair use requirement was error and should be reviewed by the Supreme Court. Anything you want to add to this, John?
I think certainly the fact that they've asked for the Solicitor General's opinion on this issue suggests that the court may be at least contemplating taking this case, which would be a very interesting development. We've seen kind of an increase in the IP docket of the Supreme Court in the last few years. And 512F has been the law for, 18 years now. And there hasn't been actually any 512 case before the Supreme Court. So it would be certainly an interesting development. Of course, with the court in the state it's in, who knows what's going to happen? It's hobbled with only 8 justices. The other thing I would add also is that the subjective criteria for this good faith requirement enables you to kind of also cherry pick lines of fair use cases, and based on those also say, hey, I have a subjective belief that any kind of use of a copyrighted work is an infringement. There are cases from the appellate courts that state just that almost write out fair use entirely. There's a case from the Sixth Circuit called Bridgeport, which says that any use of a sound recording without the copyright holder's permission is per se an infringement. Now that case has been called into question by other circuits, but if you're simply exposed to that case, one might argue Universal had a perfectly good subjective good faith belief that this was not fair use, even though when one takes a step back, this looks like a quintessential form of fair use, a non-commercial use by a mom celebrating a candid moment with her child in a forum that does very little harm to Universal or its interests.
And I want to chime in there that the fair use analysis is a complex, subtle analysis that it changes on a case-by-case basis. I mean, this is it's not easy for people that do this for a living to agree on whether or not something is fair use, and you wouldn't know for sure whether it's fair use until a judge tells you that it is. So, it sort of brings in, more thorns to the problem of what does it mean to have a subjective good faith belief that this is fair use. This is it is putting the responsibility, or I guess the power to subjectively believe whatever you want to believe, I don't know. It's problematic, to say the least.
Yes, it is. And we will see if the Supreme Court agrees and decides to take that case. That's one of the cases it might take up in the current term. We have one other Supreme Court case that we've mentioned on the show before, the Star Athletica case, which was just argued this week, that we're going to get to before we leave our copyright topics here. But before we leave the DMCA safe harbor topic, there's one more decision we should discuss. This from the Second Circuit Court of Appeal involving MP3 Tunes, which was the successor entity to mp3.com and involved sideloading and lockering of files that were argued to be infringing. MP3 Tunes has been fighting this case for quite some time now, had success in the district court, but the district court had to go back and re-examine that outcome in the wake of the Second Circuit's Viacom case. And now that they've analyzed again what's gone on with the trial court, there's a new and pretty plaintiff-friendly decision out of the Second Circuit that has broad implications for these 512 safe harbors we've been discussing. John, have you delved into this at all?
Yeah, the decision was based sort of on two different prongs of the DMCA safe harbor that we've talked about. First, of course, the DMCA safe harbor doesn't apply if you have actual or sort of constructive knowledge of infringement on your network. And the constructive knowledge prong has really been read as a test of either willful blindness or red flag knowledge. In other words, circumstances that would lead you to believe there is infringing activity clearly occurring on your network. And then the second issue in the MP3 Tunes case was the repeat infringer policy and how it should be reasonably implemented. And I would say, certainly without a doubt, the decision is plaintiffs friendly. It gives some additional wind to the idea that under the willful blindness or red flag knowledge test, you don't have to have actual specific knowledge of a specific infringement occurring. That broad circumstances could be enough to impute knowledge of infringing activity. So the court in the case gives two examples. One, the fact that MP3s were not licensed by the recording industry prior to 2007, so that MP3 Tunes should have known prior to 2007 if it had an MP3 on its network of a professionally recorded work that was not licensed. So it should have known it was infringing just based on the fact that the major record labels hadn't entered the MP3 market. And then secondly, they should have known that the Beatles had not licensed their works. That was popular knowledge, and they admitted, in fact, that they did know that they hadn't licensed their works for use digitally, and yet there were Beatles works on their network that they could have sussed out. And so the court found that was sufficient, at least, to create an issue of fact as to whether they had red flag knowledge. The other issue was, of course, the repeat infringer prong, and there the court basically suggested there may be some affirmative duties on the MP3 Tunes, the defendant in that case, to actually suss out some of the repeat infringers. And it took a broad view of what repeat infringers meant. It didn't just mean people who are uploading content, but took a view that it could also mean individuals who are downloading content illegally as well.
Got it. Wow. Emery, were you disturbed by this decision?
Actually, I wanted to ask John a question about the relationship between red flag knowledge and willful blindness. Because as I understood it, those were two separate tests, but they're not really clear. Could you maybe talk a little bit about that confusion?
Yeah, and the confusion stems from the Viacom ruling. I think no one is clear on the exact relationship between the two tests, whether in fact willful blindness is red flag knowledge, or if willful blindness and red flag knowledge are two separate things. There's some suggestion that red flag knowledge may be somewhat different than willful blindness, and that red flag knowledge still does require specific knowledge of an actual infringement occurring, whereas willful blindness might be sort of burying your head in the sand. And that's certainly what the MP3tunes.com case seems to be suggesting, is that there's a distinction between the two. The confusion,
it seems like there's a relationship between. It seems like there's a relationship rather between the red flag knowledge and the requirement, or the lack of a requirement for service providers to continually I'm missing the exact verbiage right here, but to continually monitor and create profiles on their users to update and track that information.
Right. There's an express term in the DMCA that suggests that nothing herein will require internet service providers to have affirmative duties to sit around monitoring their users. And I think that particular phraseology may be in tension with the MP3 Tunes cases holding here, where it seems to suggest there actually may be some affirmative duties under certain circumstances that the ISP must undertake. That said, that very language is problematic because we all know there are affirmative duties on ISPs. Usually they're triggered by something, whether it's a takedown notice or information of some sort, it seems like the language that's embedded there is inconsistent with the very terms of the DMCA. So I think there's a drafting problem there as well. That people who argue that the DMCA needs to be rewritten certainly point to as problematic.
Right, and it seems
Denise,
like this.
Sorry,
it
go
seems
ahead,
like
Denise.
this new MP3 tunes case, sort of highlights the censorship problem as well. Because if the triggering mechanism for someone like YouTube to have to start keeping tabs on users is their receipt at some point of a takedown notice, there's no way of policing whether that takedown notice has any legitimacy. I mean, there is, I guess, this new requirement under the Lens case that fair use at least has to be considered, and we've already talked about how there's complication about how that has to happen. But if it is, if you're sending takedown notices either erroneously or automatically without sufficient analysis, there are a lot of automated systems that just flag things that might be infringing and fire off a notice. Or if you're doing it with bad motivations, such as censoring the actual video, it seems wrong that then that user who actually had a legitimate piece of work on the site that was not infringing is now put in the bucket of people who have to be monitored by the ISP. Do you agree, John?
Yeah, no, absolutely. And I think that points out one of the other problems with the 512F and takedown regime on the user rights side, which is, most people, don't know about how to do the counter notification. Most people aren't aware of the provisions of 512F. And even if they are aware of the provisions of 512F, they're not anxious to get into a lawsuit with a major content owner that has deep pockets and can fight the case for years and years and years. And so most people are going to be hesitant to fight notifications and takedown notifications, even when they have a very good fair use argument for the reasons we've identified before. Fair use is tough to prove. It takes a lot of money to prove something is fair use. It's very fact dependent, and engaging in litigation on fair use is tremendously costly. And most people would, in the end, are going to end up, foregoing what fair use rights they may have in those circumstances because they'd rather not get involved in, 9 years of litigation, as has happened in the Universal v. Lens case. And so those takedowns then are going to count as strikes against an individual on the repeat infringer policy, and that can be problematic.
I know previously we've had guests come on that have suggested sort of a small claims court for copyright claims. I know in your paper you suggested a federal anti-SLAPP statute for copyright. Do you want to talk a little bit about either of those two options, or if you think either of those two options would help to alleviate this problem of the economic disincentivization to argue your fair use rights?
Yeah, I think certainly a small claims venue might be useful, especially because there are so many acts of copyright infringement that are occurring. And the reality is most of them aren't multi-million-dollar acts. Unfortunately, part of the problem in the law is the vast greatness of the availability of statutory damages and how high they can run that immediately takes almost any de minimis case of infringement and slaps 6 or potentially 7 figures of damages on it. That's highly problematic. But if we could scale back statutory damages in a way that still provides important disincentives for infringement, but also has some link to the value of works, and then refer cases below a certain threshold to small claims court, that could certainly be a valuable tool in terms of dealing with copyright infringement claims. A federal anti-SLAPP statute is something I propose, and I know there's legislation that's in the works in terms of bringing that to the fore. But as people may or may not know, many states have implemented anti-SLAPP statutes to deal with waves of litigation that are increasingly being brought to suppress individuals' First Amendment rights. Copyright law, of course, is exclusively federal at this point, and so none of the state anti-SLAPP statutes can apply to copyright infringement claims. However, with the rise of censorious copyright infringement litigation, I think there's good reason to consider a federal anti-SLAPP statute. And for those unfamiliar, the way an anti-SLAPP statute operates is it puts an onus on the plaintiff to show at the early stages of a case that they have a probability of prevailing. If they don't, then the defendant automatically wins the case and also automatically receives attorney's fees. And this is a significant hurdle that plaintiffs have to cross. And I think it makes it certainly would make plaintiffs think twice about bringing copyright infringement litigation where there is a very viable fair use defense or where a rights holder is overstretching in a way that is not disincentivized currently.
Right. And I always like to remind or advise our non-lawyer listeners what SLAPP stands for. It's strategic lawsuits against public participation. And so the reason we have laws against that is for this bad motivation, censorious motivation kind of theme that we've been discussing throughout the show here, that you shouldn't bring a lawsuit just to shut someone up. What the SLAPP statutes or anti-SLAPP statutes require is that you show the merits of your case early on, as John was saying, and to be able to demonstrate that you're not just filing a lawsuit to make life miserable for the person who engaged in the act. Let's see, what else do we have on this? We have, before we move on to cheerleader uniforms, we have one more DMCA-related case to cover. And that one is actually, I'm not sure if it's still in progress or not, John, but it's being handled by your law firm. And I thought it was really interesting because it involves whether or not the involvement of moderators policing conversations can deprive a site of its ability to invoke the safe harbors. Can you give us a bit of insight there about your LiveJournal case?
Sure. So in that case, we're representing the plaintiff. So I hereby disavow everything I've said to date on this broadcast. Our client there is a photography agency that takes photographs of celebrities, and LiveJournal is a entity that serves as kind of a sharing forum. And one of LiveJournal's policies on one of their particular sub-sites, which is called Oh No They Didn't, basically encouraged users to post entire full copies of professional sourced content on their website. And this was not just by users, but also by individuals who were moderators. One of these moderators was also an employee of LiveJournal. And so, one of the prongs of the DMCA Safe Harbor is that it provides protection against user-generated content, the implication being that it protects service providers who are wholly passive when there's infringement activity occurring on their network. In other words, it's not the network's fault. Our argument is that this is very much LiveJournal's fault. They are encouraging fully sourced, complete copies of articles with professional photographs. They're reproducing them in high resolution, and they're not just having their quote unquote users do it. They're also having their moderators do it, one of whom is an actual employee, and the others of whom we argue are agents. And so the argument would be under the DMCA, this is not truly user-generated content, and as such should not be protected under the safe harbor.
Right, and it sounds like you can. It sounds like you can envision other cases, not the one that your firm is handling, where moderators could be involved, and yet the DMCA safe harbor remains in place.
Well, sure, and that would be other cases involving different circumstances. And yeah, I mean, obviously, I'm just commenting on this particular case. And just so you're aware, the case was just argued in front of the Ninth Circuit and has been in the hopper for a while. So we anticipate a ruling, sometime soon. And it's a fairly important case that has gotten a lot of amicus support on both sides of the equation and received a fair amount of attention. I think the Hollywood Reporter actually called it the YouTube of the West Coast. And although I won't go that far in signifying its importance, it is there are only a handful of DMCA safe harbor rulings that have come out of the Ninth Circuit. The Ninth Circuit is, of course, colloquially referred to as the Hollywood Circuit. And so it's entirely possible that the decision could have very, very important implications, both for Silicon Valley as content users and Hollywood as content owners.
Great. Well, we will continue to keep an eye on that and look for the Ninth Circuit to give its decision. Speaking of cases that have just been argued, the Star Athletica case before the Supreme Court that we've mentioned a bunch of times on the show was argued this last Monday, and the justices really didn't tip their hand as to how we think the case might go. It sounds like there were all kinds of questions that justices were bearing in mind, sort of real world ramifications of what their decision might mean. Justice Breyer was asking about, he challenged one of the lawyers by saying, if suddenly in this case we say that dresses are copyrightable, and they are because every one of them has some design element. That's what this case is all about, whether the chevrons and zigzags and things on a cheerleader uniform are specifically copyrightable, which one of the parties, Varsity Brands, is contending in this case. And Justice Breyer is concerned that if we're saying that now clothing is copyrightable, we're going to double the price of clothes. Also, Justice Kagan asked about things that were, one of the arguments in the case is that the chevrons and zigzags and things aren't not copyrightable, I guess is the right way to put that, because they serve a purpose, like perhaps making the wearer look slimmer or more athletic or something like that. And she mentioned there are all kinds of structural things you can do that are slimming, and maybe copyright should be granted on that basis. So it's tough to say where the court's going to go on this, but it was argued this week. Care to hazard any guesses, John? Justice Breyer tends to be an IP skeptic all the way back to his days before being a Supreme Court justice. He famously wrote a very interesting law review article called The Uneasy Case for Copyright. And over the years, he has been someone who has questioned the expanding scope of copyright. So I'm not surprised that the tenor of his questions were, in fact, in that vein. I think Justice Sotomayor seems similarly concerned about the implications of one company having a monopoly that lasts a century on chevron stripes and certain types of color blocks. And I think the case is particularly fascinating because of how one defines functionality. Are these chevrons and blocks more functional because they have a slimming effect? Are they functional because they are simply what people expect a cheerleader outfit to look like? Or are they not functional because they literally don't make the outfit work? After all, an outfit for cheerleading works whether it has chevrons and stripes on it or not, in a most literal sense. And I think a lot of the action is going to be how we draw the line on what functionality is. There's some analogous case law in trademark law with the doctrine of aesthetic functionality that may come to bear. But my expectation is, based on the court's recent IP jurisprudence, that they don't take a really strong position on the outcome of this case, but rather enunciate a test that they then hand down to the lower courts to try to make sense of. That's certainly the case in the most recent foray into copyright law, the Kurtzsang case involving attorney's fees. Right. Hopefully not a 4-factor, really hard to apply test.
but entirely possible.
Yeah. Emery, any thoughts on cheerleaders and chevrons and et cetera?
No, I mean, John covered everything. I think that, we've talked about this case a number of times before. Yeah. It seems like this is more of a issue that should be dealing with consumer confusion than copyright. It seems to me that cheerleading uniforms are basically flags that you wear. And so it seems kind of weird that this is all being handled in a copyright context. And I do think it's kind of some of the possibilities that was it Justice Breyer that expressed concern that, so we say that school uniforms are, or that we say that cheerleading outfits are copyrighted. Does that mean that a school that, starts with one company's cheerleading uniform is then locked into that single company for the rest of it forever? for the 75 years plus the plus the life of the author. These are questions that will have to be worked out. So it'll be interesting to see which way the court goes.
Right. All right. Since John practices not just in the area of IP, we've spent a lot of time on copyright this episode, but in the area of entertainment, let's scoot on over to Hollywood and look at a couple of developments in entertainment law. We let you know back when it happened, when Hulk Hogan received his $140 million verdict against Gawker, which resulted in Gawker's bankruptcy and interesting ties with Peter Thiel, who had funded the litigation and has come out publicly and discussed why he did so. There has been a settlement in that case now. So even though the plaintiffs received a $140 million verdict, they have now agreed to settle for $31 million. Not too much to report there other than that happened. I'm just wondering, John, if you have any thoughts about the settlement or the case in general.
Well, I do. I mean, I understand Gawker's incentives to settle the case. They've been through a lot. Obviously, they've declared bankruptcy, but the attorneys on behalf of Hulk Hogan have not just been going after Gawker, but after individual writers for Gawker, and this has created such a huge cloud of potential liability that I understand they may have had no choice to settle, but to settle. But the entire lawsuit seems to me deeply problematic. Peter Thiel's actions in terms of harboring a grudge for a decade and then looking for the right lawsuit to finance against a entity that wronged him many years ago seems deeply problematic for the future of investigative journalism. Like Gawker, hate Gawker. Whatever you may think of them, over the years they had some profoundly stupid stories, and they also had some profoundly interesting ones, and ones that actually did speak to public concern and public issues. And their voice is now gone, for better or worse. And it's because of a particular lawsuit that, honestly, the verdict in the end, I think, rested on shaky grounds. And if this case had gone up to appeal, I think there were significant issues with what happened at the trial court. And also significant First Amendment problems with the verdict that may have led to its reversal. And it's unfortunate that we're not going to be able to have that chance to see if a court applying constitutional principles would actually reverse the verdict, because now the judgment stands as it was adjudicated by the trial court, and it's forever going to remind future journalists that if they push a celebrity the wrong way, and that celebrity is only a single-digit millionaire, as Peter Thiel called it, rather than a billionaire, but can find a billionaire friend, they're going to be incredibly cautious about going after that person or doing anything that person doesn't want. So I am profoundly concerned about the future of journalism because of the actions that took place here, and I'm disappointed that we won't get the benefit of an appellate review of the case to consider some of the more weighty First Amendment issues.
Where was the trial in this case? Do you recall? It's been,
I believe it was
going
in Florida.
It was in Florida. So yeah, I was just trying to sort of spin out which court of appeal would have been involved. Is it sort of a silver lining for media and journalism companies that this was just a trial court decision and its precedential value is very small?
Not necessarily, because every would-be litigant is still going to point to this as saying, you want me to go after you like Hulk went after Gawker, and look how much money he won. Right. They'll never be able to answer back, yeah, that was reversed on appeal. So I'm not sure there is that silver lining here. I get why Denton had to do it for not just his former company, but also for the people who were working for him. But I think it's disheartening in terms of commentary on the high expense of justice and the distribution of access to the American justice system that occurred here.
I suppose they could answer, yeah, but it would have been, or it likely would have been overturned on appeal if Gawker had just been able to go the distance.
Right. They certainly can, and that argument will always be out there, and there will be future cases like this. TWiL has launched an entire, I believe, business now that is bent on the financing of lawsuits, which raises some interesting ethical issues. On the flip side, it does raise some distributional issues that are actually not entirely negative. For example, the idea of funding litigation can provide people who may have meritorious claims but otherwise can't afford litigation to actually be able to vindicate their rights in court. So it's not entirely bad, at least from that point of view. But it raises a lot of provocative issues.
Right. I remember we discussed way back. I think it was in May of this year when the Met Gala happened and there was a controversy over Katy Perry's dress. I remember we had a brief discussion about that. I didn't realize at the time, John, that this was a case that you were involved in some way. So I wanted to bring that back up and talk about the design of her dress, since we've been talking about dress designs anyway in the context of Star Athletica. Can you remind us what happened here and pull out the interesting tidbits for us?
Sure. So this was a case where my client Jeremy Scott and the noted fashion house, Italian fashion house Moschino, were sued by a graffiti artist for the alleged infringement of some designs of graffiti on a dress that both Katy Perry and Jeremy Scott wore at the Met Gala last year. And the case ended up being resolved amicably. But one of the pending issues that wasn't decided by the court, but was briefed on summary judgment shortly before the settlement, was a question we had raised, which is, can an artist claim a copyright in a work that is the product of illegal activity? We alleged in that case that the artist Rhyme had engaged in an act of trespass in creating his graffiti in a building in Detroit, and we had provided a declaration from the owner of the building suggesting that he had not given any permission. The other side denied that it was without permission, but putting that aside, it does raise an interesting question in copyright law that has never actually been adjudicated by a court, which is an illegal work still subject to copyright protection? We argue that it shouldn't be, in part based on the equities, the idea that one should claim a property right when the very act that gave rise to that property right was a violation of someone else's property right seems deeply problematic. And of course we alluded, we had a analogy that was intentionally provocative. The murder, the Black Dahlia, claiming that what would happen if the murderer of the Black Dahlia claimed a copyright in his particularly unique slash markings on victims' bodies, and then proceeded to sue police officers, police officials, as well as newspapers that reprinted those photos, because technically they would be an unauthorized derivative work of his slash markings. And we said that would be preposterous, because you should not have a copyright when you engage in an illegal activity. You should not be able to benefit from a monopoly granted by the state when you're violating the very laws of that state, which are giving rise to your rights. Right. Now, of course, we weren't suggesting that the graffiti artist was a murderer by any stretch, merely a trespasser. But it does raise some profoundly interesting issues. Let me convey one that didn't come up in the litigation, but which I've thought about subsequently. One of the, we were just talking about the Hulk Hogan lawsuit about, the invasion of his privacy with Gawker playing that sex tape. But there was another lawsuit that was adjudicated right around the same time involving Erin Andrews. If you remember, Erin Andrews was, of course, famously the victim of a peephole stalker who basically leaked footage of her on the internet. And she went after him and got a large judgment. But one of the weird things about that case was, in order to enforce her ability to take down footage of the stalker footage, the peephole footage, she actually had to purchase the copyright from her perpetrator. Why? Because one of the default rules in copyright law is the person who films it gets the copyright. And to me, that seems to be a very good example of why we may want to consider the idea that if you engage in an act of trespass and you are illegally filming someone in the privacy of their hotel room through a zoom lens that you have basically carved into the wall, you should not be entitled to a copyright, which you can then subsequently exploit and earn licensing revenue from. That seems deeply problematic, and I think it's very much an extension of the argument that we made in the case involving Rhyme and Moschino and Jeremy Scott.
Is it true, John? You said this has never been adjudicated by a court. That no graffiti artist has ever, if they haven't obtained permission to decorate whatever surface they're decorating, that they've never successfully prosecuted a copyright case?
Well, this issue has never been actually litigated all the way. So it hasn't been raised as a defense where the court actually ruled on the merits of the issue. I think in part, number one, the value of graffiti has only come to bear in recent years. Graffiti is incredibly hot in the art market, as is all street art. That's something that's really happened over the last decade. I would also suggest that most graffiti artists, many graffiti artists, have a credo that's anti-property rights. And so to be consistent with that, it seems odd to be going out and enforcing your property rights when you're suggesting that you shouldn't respect the copyrights or real world property rights of others.
I don't know, though. Why wouldn't you just want to prosecute the people for the actual laws that they've broken and still grant them the copyright in the creative works that they've created? I mean, it certainly rises above the level of creativity necessary to get copyright. It's fixed in a tangible medium. I mean, it seemed really problematic and dangerous to me reading your argument that, illegal works or works that were but for an illegal act would not have been created shouldn't be given copyright. And I understand the argument that you're making. I read through yours and the response, and then your response to their response, and I appreciate the contradiction here, and giving people that seem to rebuke property rights of others a property right in the intellectual property that they create. But it seems like you're there are laws that they've broken. You should prosecute them for that. But it is still a copyrighted work. It is still a creative work. I mean, it seems like I know that the opposition had brought up the argument that, well, are you saying that, if Jack Kerouac wrote, his books on a stolen typewriter, then it wouldn't have been, then that work would have been illegal. And you have said that, no, that's not the case. That's not a fair analogy because, the stolen typewriter would not have been the reason why the book was written. But I mean, my mind is starting to race here. Obviously, the clearest analogy here, I think, is Banksy, who strolls into a museum and illegally places his art on a wall there, or necessarily places his art illegally on the streets or on a wall where it's he didn't get permission. It seems like as the purpose of copyright is to encourage the production of the creative arts and the economic incentives we were talking about earlier, that you would still want to allow those works to be protected, that they are and obviously they have a market for it. I'm sort of rambling here, but it seems really problematic. It seems like if the Jack Kerouac example wasn't a good analogy, maybe Hunter S. Thompson's Decadent Day at the Derby, where certainly probably a felonious amount of drugs that were ingested were necessary, the but-for cause of why that book was written. Would that work be considered an illegal work that would somehow not be deserving of copyright anymore?
I think that's a very different kind of analogy, and I sort of would suggest that if he's on illegal drugs, that's a completely separate issue. I mean, it's impossible to provide proof that would be the but-for cause of him, although we might certainly think that, and he might agree that it was the but-for cause of his actions. But that said, I think the case that we were dealing with at hand was far different. I mean, there was an act of trespass that actually literally gave rise to the creation of the work. It was the trespassing was the creating. And I think it's problematic.
That was also an issue to be decided in. I mean, that was a disagreement, right? I mean, there were facts that were presented on both sides, as I understood it.
I'm assuming if it was a trespass, and I agree. The other side suggested it wasn't a trespass. We had a declaration from the property owner suggesting they had never given permission to the artist to do that. But more broadly, look, I understand your position. I think one of the things we have to backtrack to is look back at copyright. What is the purpose of copyright? But also, what is the origin of copyright law? Copyright isn't something that naturally occurs. It's not a natural property right. It is something that is given by the state. It's an artificial creation by the state that gives you a limited monopoly in a right to exploit a particular work. I'm not sure Banksy has a problem with people ripping off his works and doing their own versions of Banksy's. I'm not aware of him litigating those cases, in part because maybe he actually doesn't take a property view of his work. So I'm not sure Banksy would have any problem with not being able to have enforceable copyrights. The truth is, for Banksy, the value of his work isn't in the copyright. It's in the value that it's an original Banksy. It's the trademark. It's effectively that there's a difference between real Banksy and a fake Banksy. And he has every ability to recoup whatever money he wants to gain from his work, even though he maintains his anonymity, simply through enforcement of his trademark rather than his copyright. So I think there's plenty of protection still for the artist. But copyright is an artificial monopoly granted by the state as a reward for creativity on the theory that you're doing some kind of social good. If in fact you are breaking laws in the process of creating a copyrighted work, and specifically those laws are the actual basis for the creation of the copyrighted work, I think there's some reason to be concerned about granting copyrights, because they are a 70 years plus life monopoly that has profound consequences on the propertization of creativity. But I'm not without my doubts about it. I mean, I certainly would hesitate to go down the road of having a very expansive notion, as you mentioned, like Hunter S. Thompson not having copyrights because he simply engaged in drug use. But I think that's not analogous.
I just keep thinking, John, that given the visual scheme of the Suicide Squad movie, I'm surprised that your Black Dahlia example didn't come up in real life. It seems like something that you would have incorporated. Go ahead.
It may well come up in the future, yes. I suspect.
Yes. P.S. Chops just gave me a great second MCLE passphrase for our show in IRC. Thank you, P.S. Chops. And that is, who owns the cave paintings, based on the discussion that we've been having about graffiti. That's our second passphrase for the show, so I hope you've got those jotted down. We'd also like to thank our second sponsor for this episode of This Week in Law, and that is Grasshopper. Grasshopper is a virtual phone system designed for entrepreneurs. Grasshopper works just like a traditional phone system, but it requires no hardware purchase or software installation. With their iOS and Android app, callers can reach you wherever you are on your mobile phone. Grasshopper allows you to keep your existing number so you can maintain your brand. When you make a call, your client will see your Grasshopper caller ID instead of your personal phone number. Simply select a toll-free or local number, record a custom greeting, and add multiple extensions for your business. Toll-free numbers are great for marketing and make your business sound more professional. Set up department and employee extensions with custom call forwarding to any phone in the world. Get your voicemails emailed to you as audio attachments. You can also send and receive SMS text messages from your business number. Join the over 250,000 Grasshopper customers today. Plans start at just $12 a month, and you have a 30-day money-back guarantee. Turn your smartphone into a business line with Grasshopper. To save $50 on your order, go to trygrasshopper.com/twit. That's trygrasshopper.com/twit. Thank you so much, Grasshopper, for your support of This Week in Law. All right, just one more entertainment story before we move on to other stuff. Actually, it's sort of loosely an entertainment-based story. I'm going to quote Drew Hess on Twitter, who tweeted, Did you know that Disney has open sourced a blockchain implementation? Of course you didn't. That's absurd. But no, really, that's what's happened. Disney has open sourced a blockchain implementation, and there's a good piece at the Cointelegraph writing that up. It's sort of speculating on why Disney might have done this. The thing that popped into my mind is perhaps thinking of registering their creative works on a blockchain, but that's not one of the points the author mentions here. Some other notions why Disney may have created a blockchain have to do with tracking points as customers play games at their theme parks, introducing tokens or some sort of currency that could be used at their facilities. It's a multi-currency capable blockchain. It's called Dragon Chain, by the way, if you want to look into this further. So I just thought that was an interesting development. You don't really think of Disney as coding up a blockchain and then open sourcing it, but they did so. You also might not think of weed on a blockchain, but that is something that's happening too. A company called Medicinal Genomics is creating a repository of cannabis genomes, which are stored on the Bitcoin blockchain. And I guess the purpose of that would be, again, sort of protection of your genome in a property right, intellectual property kind of way. So there's a record of it in case your genome is being used without your authorization, and you can go to the blockchain and demonstrate that. So just a couple of quick things to note on that. Any thoughts, Emery?
A few, I guess. The Dragon Chain stuff. First off, I guess none of us should really be that surprised that Disney is doing this. Disney has never really shied away from implementing aggressively new technology, whether it's, virtual reality or animatronics or CG. The Disney parks right now are high-tech wonderlands under the surface. The specific implementation here, I was talking about before the show, it's a little difficult to draw any interesting legal tech conclusions so far, but, specifically technology-wise, looking at this, what the Bitcoin blockchain is based on a concept that, you want to create a trustless distributed ledger. The idea being that you don't want to have to rely on anyone to trust any part of the blockchain. And it does this by requiring a proof of work on each transaction. So the Dragon Chain implementation does something a little differently. By instead of having proof of work, what they're trying to do, essentially, it looks like, is create a sort of open blockchain that can be used with trusted implementations of blockchains. So rather than having a trustless distributed ledger, you would have more private blockchains that may be, you trust entities that can have, write privileges on the blockchain that, can overwrite what everyone else writes on it. So as far as use-wise, as someone that's, been in the Bitcoin space, I think a lot of people tend to discount basically private blockchains because essentially if you don't have a proof of work, if it's not trustless, then it is, not really different from just a database that anyone can access. As far as seeing what Disney is doing with this, I think it's going to be really interesting seeing how they implement this in on the back end for their parks. Like you were saying, I think, immediate uses that pop up are, tracking accounts. People that have, year-long Disney passes, I'm sure they want to be able to implement some kind of gamification points to that. I think they're probably already doing that, if I'm not mistaken. So it'll be interesting to follow this. I think that what Disney is doing with Dragon Chain is probably trying to create a blockchain for other corporations and other businesses that may want to roll their own mix of trustless and trusted blockchains. And the way it does this is kind of cool. So neat on that front. And then the weed blockchain stuff, I think that's actually more immediately exciting to me, I think, because it is a really interesting, neat concept. The way that the company works is that they have genome sequencers, and distributors or growers can send the seeds of their plants to this company. They will sequence the genome. They will hash that sequence with their private key and then attach that to a transaction on the blockchain, a Bitcoin transaction, so that down the line, anyone that says that or tries to question what strain that grower is using, or tries to claim ownership of a strain that one grower is using over another, they can point to the blockchain to that specific location. It will look like just a random string of letters and numbers until it is decrypted, at which point it will show the actual sequence genome of the plant, which is very cool. But whether we've actually, this obviously comes back from, I think, last year or the year before that, when the first marijuana strain was patented. So how this would all play out in actual patent litigation, I don't think we've seen any blockchain as evidence yet for prior art in patent litigation, but it certainly is coming down the pike eventually because people recognize that it can be used that way. So that's all I've got on this.
It sounds like if weed growers are using blockchain in this way, then other drug companies, commercial drug interests, of course, weed is a commercial drug interest as well, but more conventional ones might also decide
My first
to
hot
make
take
use.
was weed found a use for the blockchain? I am so surprised.
Exactly. All right. Well, we're going to move on to a quick privacy story. Bad news for you if you like to use drones and you happen to be in Sweden. A court in Sweden has decided that if you are going to operate a drone in that country and that drone has a camera, you are going to have to obtain a special surveillance permit in order to do so. We don't know yet whether what the process is going to be for getting those permits, how expensive those permits are going to be, but it severely curtails drone use in the country. Many drones, all of those by DJI, GoPro, and Parrot, for example, have cameras on board for the notion of using them as aerial photography vehicles and videography vehicles. So I guess this is the reason I bring it up is it's, as far as I know, the first country that has enacted a law like this, and it does sort of jump into the breach that people have criticized the FAA for here in the U.S., not taking into account that as it promulgates regulations around drone use, it's not really paying attention to the privacy piece. Sweden has gone the other direction. Any thoughts, Emery?
Yeah, I do, actually. First of all, I like the idea that, well, I don't know. I don't want to come off as sounding too excited about this because I think this is probably not the greatest idea. But on the idea, first on the front to that, this is somehow aggressively more regulation than we have in America, I think is not necessarily true, if only because the FAA regulations basically prohibit anything that would be useful with a camera. And
Yes.
They prohibit you from doing things like you cannot fly your camera over or your drone over anyone that is not participating in the activity. Which, as you fly your drone up 150 feet, you suddenly have a view of, I don't know, a lot of space. And a lot of people that are clearly not going to be participating. So, I think that a lot of ways this regulation from a privacy perspective, I can applaud for recognizing and using the word surveillance in it. I like the idea that they just come out in front and center and say, look, if you have a flying camera in the sky, this is a form of surveillance. And if we're concerned about people violating the privacy of others or businesses violating the privacy of others or governments violating privacy using these things, we should just call it what it is. And it's a surveillance. You need a surveillance license if you want to be able to fly a flying camera. I can sort of get behind that, and I think that it's not really any worse than the unworkable regulations that we have here, because
Right,
again,
Yeah, I totally agree with you that the FAA regulations we have for drones now maybe, aren't designed to be privacy protecting, but that is their impact because in order to comply with the various requirements to fly a drone, you're going to have to jump through a lot of hoops and maybe, just turn away. Maybe there's a chilling effect simply to the amount of regulation that is involved. John, any thoughts?
Yeah, I think it certainly, shows Sweden's commitment to privacy issues. At the same time, I think if we had a similar regulation here, you'd have to be concerned about the degree to which, the permits are obtainable, how expensive they are, and the First Amendment implications of that.
Yeah.
Who's just going to give access to drive drones? Is it going to be only a limited few, or and what does this impact, in terms of the rights of the free press, et cetera. So I'd certainly be concerned on those grounds as well, not to give short shrift to the privacy interests.
Oh, absolutely, yeah.
Okay,
and clearly,
so
I think industry-wise, it's curtailing right from the beginning a huge number of all the most interesting aspects of drone businesses that could exist. So, it's not that great, but yeah.
Great. Moving on to a trademark issue involving nasty women. So I don't know if it's just because I see the world through an IP lens, but as soon as Donald Trump called Hillary Clinton a nasty woman at the last debate, the first thing I noticed as aftermath, aside from people being outraged by the comment, was all of the products that came in its wake. The T-shirts, the mugs, the lawn signs, you name it. I mean, people were putting nasty women on everything. And it gives rise to the question of who gets to trademark that phrase, whether there are copyrights involved, et cetera. And there's a good post at The Fashion Law looking at the budding trademark battle for nasty woman apparel. So I just wanted to highlight it in case anyone else sees the world through the same lens and was wondering if there were going to be legal repercussions to the fact that these products immediately started proliferating the day after the comment was made. If you went on Etsy, you could have found probably 100 T-shirts with that phrase specifically for folks who were interested in declaring that they were nasty women too. John, any thoughts?
Yeah, I mean, one of the interesting things that came up in this piece is the enforcement strategy of one of the people who filed an immediate application with the trademark office and their plans for going aggressively after the Etsy users, et cetera. I immediately was thought about how aggressive enforcement efforts like that can sometimes backfire. First of all, they haven't even received the trademark yet. They've merely filed it, the registration. But the article mentioned that there was a pre-existing brand called Nasty Girls, and arguably they could say that Nasty Women is a derivative of Nasty Girls and conveys the same commercial impression. It creates a likelihood of confusion. And so once you start suing people, you can have people who were there before you come after you then. And it could lead to an ugly war of intellectual property attrition. So I thought that was an interesting part of the tale, that the yes. particular people rushing to trademark this with the PTO were already looking for a way of gaining a monopoly through litigation and takedowns.
Right.
So I was hoping that Mike would be on the show today, but I guess I'll put this out to you guys. Does anyone know if I saw someone on Twitter just exclaim, is this really the way it works? For trademarks, is this really during an election? Is it just a race to the USPTO to trademark something that was not said by you so that you can start aggressively preventing other people from using it?
Yes and no. I mean, famously, there've been examples of this where, Pat Riley, of course, famously owned the trademark to three-peat because of his LA Lakers way back in the 80s. And he was smart enough to get the trademark. Or, there was the expression Tebowing that was hot in the NFL for a while, and people raced to get a trademark on that. People do race to the trademark office, but that's not the test of who owns the rights. I mean, first you actually have to make use of the mark in commerce. And this individual immediately put out T-shirts. So at least that was smart, and registered it with respect to T-shirts. But pre-existing users are going to have rights in the trademark, and the scope of your rights are going to be limited to the particular area where you're making use in commerce, as well as reasonable expansion room. So it's not quite as simple as racing to the trademark office, filing an application, and thereafter being able to prevent everyone who uses the term nasty girls from making use of that term. It's certainly not as easy as it sounds.
Do you think that now with, markets like Etsy and, the innumerable number of T-shirt printing services or whatever, you can go from, a picture to a T-shirt in like 30 seconds. Do you think that has any relation, or should it have any relationship to the requirement for trademarks that you're commercially exploiting your work or the trademark?
Well, the requirement, as it's been read by the trademark office and courts interpreting it, is pretty low threshold in terms of what you need to do to be commercial use. I mean, certainly, look, if you slap on the mark on a few T-shirts and put them up for sale on Etsy, you have a colorable claim that you're now making use in interstate commerce. Back in the day, of course, it was far more difficult. You actually had to buy some kind of printing press, or and you needed much more complex technology that took months to obtain. Now we have that all in front of us, and so it certainly has quickened the time from which someone can go from concept to actual use in commerce, which is required for trademark. And it might suggest that the barrier for making use has been read to be too easy.
I'm just stunned that Donald Trump, he likes to tell people how litigation savvy he is, that he didn't go out and register it himself. It would have been, quite a thing for him to raise at his rallies. Look, I have the trademark, and all these people want to make T-shirts now because I'm so smart that I said this.
I'm sure he's aggressively protecting Make America Great Again. I haven't checked the trademark filings, but I suspect he's filed a trademark on that, and I know he's got a good cottage industry going on hat sales of that. So he's working brand Trump pretty well. I guess he might be upset at his people for not jumping on the nasty women thing.
Right. Well, as long as we're talking about people involved in educational institutions that have gone wrong, let's conclude the show by talking about Indiana Tech Law School.
Oh, I haven't seen that bumper in so long.
I know, we hardly ever do the other bumper, but that's where this one fits. Tell us what went on at Indiana Tech, John.
Well, like many law schools, Indiana Tech in the last few years has seen declining admissions. There's been over the last 5-6 years a tremendous precipitous drop in enrollment in law schools, and as a result, a lot of the schools that don't have firmly established bases or firmly established reputations have taken huge financial hits. But what happened with Indiana Tech is notable because it's the, as far as I know, the first major law school to basically close under the current, if you can call it, law school recession, and it could be a harbinger of other closures to come. I think I saw a very funny line in some legal education circles that basically said that law school deans throughout the country agree that there are way too many law schools and that some of them should close. They just don't agree that theirs should be the one to close.
Of course.
And I think that's very accurate. There was a glut in the number of law schools out there. There was a tremendous rise in the number of law schools that opened in the last couple of decades. Indiana Tech was one of them. I think they only opened up a few years ago. And it does signify an important moment in the continuing crisis in legal education, where people are questioning the value of law school, the value proposition that law school provides, the type of education people receive in law school, and also the cost of law school education. And so I think there could be future closings to come, and Indiana Tech Law is maybe only the first of several law schools that may face the situation. You do feel very badly for the law students, the professors, the staff at these schools who apparently were completely unaware of what was happening and are going to have to make significant changes in their life precisely because of this closing.
Emery, as a law student, I'm wondering if this hits close to home.
I mean, yes, no, I don't know. Poor guys. I'm sorry for all you guys that thought that this was a good idea to go to Indiana Tech Law. It was a really, really bad idea. Don't do it. It did remind me to check the bar results and I want to give a huge shout out to my good friend and previous roommate, Ryan Harris, who just last month entered the barred ranks of attorneys in Louisiana. So congratulations, Ryan. And to all my other friends that are waiting on bar results in California, good luck. But
yes.
this school had, I think, 12 graduating members, or 12 graduating 3Ls last year, and only like one person passed the bar or something. So it's, yeah, they should probably close down.
Yeah. And there will likely be lawsuits, probably on behalf of the students. Sounds like
you love
for
hearing
sure.
All the student, interviews are like, you can tell that they've had 1L contracts, because all of them said, it's just, I feel like I was promised something and I relied on that promise.
Right. I saw at least one interview with an anonymous faculty member who was making rumblings about the faculty suing as well, because of apparently monies set aside by the school that were supposed to cover the losses that weren't applied, and instead they closed. So watch that space and see if we actually see more schools closing or lawsuits related to this closure. And with that, we'll move on to our concluding material for the show, our animal selfie of the week. Hashtag first lemur. I don't think we've ever featured a lemur as our animal selfie of the week. Of course, we do these in honor of Naruto the macaque and all of the cogitation around whether animals can hold copyrights to things when they take video, as this lemur did. This lemur stole a GoPro and went on a romp. There is the lemur romping with the GoPro. Footage taken by the lemur. Other lemurs whose name and likeness are being used in this video, perhaps without their permission. So, always fun.
There we go.
There we go. There's the selfie aspect. So I don't know this lemur's particular name, but or whether PETA is involved in representing its animal rights in this video. But it is clearly the videographer. Anything you want to add, John?
It does once again raise an interesting issue of authorship, which is percolating in the courts right now. As you probably know, the ruling on the Naruto case has been appealed to the Ninth Circuit, and it's continuing to press on. So it'll be interesting to see whether courts, disagree with the Copyright Office's determination that you have to be a humanoid in order to get a copyright, right. and how they might weigh in on the potential implications of that going forward.
Yes. For our tip of the week, first I want to revisit last week's tip from episode 365 with Allie Lang, where we pretty much distilled the tip down to the word lie, meaning lie about your email address and your phone number when you're signing up for things. If you don't want that personal information about you used. Allie had some good explanations about that in our last show. Not surprisingly, a number of people wrote in wondering about the ethical and legal ramifications of lying about things like your phone number and your email address when asked for them. Some people were just in general concerned that we're moving to a culture where it's okay to lie about things like that in order to protect yourself in a defensive manner. And one listener in particular, here, let me pull out some of his discussion. Joe Habib raised something that I hadn't thought of at all, and that is the fact that under the Telephone Consumer Protection Act, I'm not going to go into a whole lot of detail here. If you want more detail, certainly I can share with you more that Joe had to say if you reach me outside the show. But he pointed out that companies have various obligations to make sure that they have valid phone numbers for people, and there are written consent requirements after 2013. And I guess where he's going with this is that if you've provided a phone number, that can be used as your written consent that you be reached at that phone number. But if people are giving out fake phone numbers and the company is relying on them in placing, robocall kind of things, then the company is exposed to liability for not having actually obtained written consent from the person with the number. And there has been an uptick in class actions about that under the TCPA. So he and I had a back and forth about, companies could start coming after people who had given them a wrong number. And the codicil to that, I guess, is that, or the corollary, is that companies really need to give people an opt-out where you can still do business with them without having to provide a number, real or fake. If you choose not to provide it, there should be a way that you can not do that, so you're not exposing yourself or the company to liability if in fact this TCPA specter is looming out there. So thank you, Joe, for that. Good discussion. Our tip this week is if you have housing woes, keep your eyes open. There may be a bot or an app for that. A couple of things to feature on that front. The app in particular can help you if you've been wrongfully evicted. It's called Just Fix, and it's trying to automate the process in the city of New York of going against your landlord if you've been wrongfully evicted. So it's not quite a bot, it's an app, but it takes you through a series of questions that help you build up your wrongful eviction case. And then Do Not Pay, which we have featured and in fact had its creator Joshua Browder on the show before, is the app that enabled people in New York and London, I believe it was, to challenge parking tickets with great success. Joshua has actually expanded that to help people who are being turned out of, it sounds like, institutional housing. Someone had been in a hospital and she was going to be evicted from that location and had nowhere to turn while still in recovery. His Do Not Pay app is going to help people pursue the process of landing other housing situations in those circumstances. So good for you, Joshua. And keep an eye out if you've got housing woes. There may be some good remedies out there for you. Our resources of the week are several. And they all involve John in one way or another. First, we have a list for you. We were talking about music and entertainment law over at Billboard.com, Billboard Magazine. They have pointed out that law schools who are creating entertainment-oriented laws have to give them a solid grounding on intellectual property in the digital age for them to be able to effectively practice. And they have put together a top 10 list of those law schools, who they think those law schools are. And John's alma mater is included there, Yale Law School in New Haven. And John is featured as an entertainment lawyer who came out of that law school. Anything you want to add to this, John?
I surely could have thought they could have found better people than me, but I was flattered. I was flattered to be listed as the designated Yale Law alum.
Right.
I'll take it.
I think you're a great example. Just to prove that that's the case, John has a really interesting looking talk coming up on November 11th at Whittier Law School. Your topic sounds fascinating: sex, drones, and videotape. What are you going to be discussing, John?
I'm going to be looking at rethinking copyright's authorship doctrine, talking about the famous monkey selfie case, as well as other cases that have recently given us pause to question some assumptions we've had about who copyright vests in and what it means to be an author. And be looking at some interesting cases involving all of the above: sex, drones, and videotape. The Hulk Hogan case, the Erin Andrews case, all from a copyright lens, as well as the monkey selfie, and some interesting cases involving some modern art.
Great. We've mentioned before, and we'll mention again in light of all of the DMCA safe harbor cases we discussed today, that John and Kelly Klaus and Lisa Borodkin, who we just had on the show a couple of episodes ago, are all speaking together on a panel at South by Southwest. The panel is called Navigating the YouTube Safe Harbor. So if you're going to South by this year, definitely catch John's panel. You excited about that, John?
I'm thrilled. I'm a big both music fan and movie fan, and being able to as one of the fringe benefits of speaking there, take part in the events and everything is going to be fantastic. And I think it'll be a great audience. And I think we have a really good panel lined up on the safe harbor, which is coming under increasing pressure, in particular from music artists who are concerned about the enforcement of their rights.
And then finally, one last resource that will apply to lawyers in the state of California who listen to the show. We give you various ways wherever you are that you can submit your experience with us here at This Week in Law to try and obtain continuing legal education. John's firm is an approved provider in California and has a number of videos available on their site, including John talking about the Aereo copyright case, which you can watch completely free, and then download their attendance form, and you've got MCLE taken care of, at least a bit of it for your California requirement. That's really great that you do that, John.
Oh, thanks. It's fun putting those together, and it's a good opportunity for us to delve into the issues more clearly and more specifically in a long format. So thanks for mentioning that.
Sure. It's been really great talking with you again on the show today. I'm so glad you've been able to join us. We hit a bunch of things that you've got coming up. Anything else you'd like to mention before we get on out of here?
No, that's it. I just want to say, really appreciate it. Thanks for having me on, Denise. Emery, pleasure being on the panel with you as well, and really enjoy the show. So I'm always delighted to do it.
Great. It's been so fun having you. Emery, you as well. Great to have you back.
As always, thanks for having me. This is a pleasure.
I'll just remind folks that we record the show every Friday at 11 o'clock Pacific time, 1800 UTC. Join us live if you'd like. Jump in our chat. Give us great ideas for things to talk about, further questions to ask our panelists, etc. We love having the live audience, and you guys really help us do the show and make it very lively for us. If you can't join us live, don't worry about it, though. You can just head on over to twit.tv/TWiL, and our entire archive of shows is there for your listening and viewing pleasure. At least the very, very old ones are audio only, but most of them have a viewing component to them. So, hey, if you're trying to get into the holiday spirit, I just wanted to mention we have this really awesome designed Merry Twitmas sweatshirt or t-shirt or tank top that you can pick up for yourself over at Teespring. It's a really cute, ugly sweater kind of design on whatever of the items you would like. It's only available until November 23rd. So head on over to teespring.com and look up Merry Twitmas if you're interested in checking it out and making your holidays more festive with Twit. We hope you'll get in touch with us between the shows. You can tweet at any of us. Emery on Twitter is Emery Roan, all one word. I am D. Howell. You can also email us. He is Emery at twit.tv. I am Denise at twit.tv. Let us know what's on your mind there, or if you'd like a longer form social media format to interact with us, find the This Week in Law page on Facebook or on Google+. Those are both great places for that as well. Let us know what you liked. Yeah, absolutely. I already put it in IRC. As I said, it's pinned to the top of my Twitter page. But if you want to contribute to our Flipboard, just follow that link that's pinned to the top of our my Twitter page, and jump on in there. We love seeing your ideas of what we should discuss on the show. Let us know who you think we should have on. If you have any further thoughts on things like lying about your phone number or your email address or anything else that comes to mind when you're listening to the show, we love hearing from you. Thank you so much for reaching out to us. And we will see you next week on This Week in Law. Take care.